Hi, everyone. Welcome back. We are talking about we're having our final notes, and that's on chapters 13 and 14, which in particular, chapter 13 is going to look at the juvenile court system and juvenile corrections. So, if we follow the trend we've been doing lately, we'll do one video on chapter 13, which will be on the courts, and then our last video for this will be on 14 on corrections. So, that being said, let's talk about the courts. That is our focus for this video. And so, in particular, they do talk about the court process. And for those of you that have taken Intro to Criminal Justice, you're already familiar with the basic structure and breakdown of how the court system works. So, in a lot of ways, the juvenile court follows the same pattern as traditional adult court. So, we're not going to spend nearly as much time talking about it, simply because most everyone who's taken this class should have been in Intro to Criminal Justice and should be at least familiar with the general structure. So, I guess I'm gonna write that down. Very similar. Ooh. To the adult court system. So obviously, there's going to be different terms for some of the stages and aspects of the juvenile court system, but for the most part, it's very similar. They are held in probate courts, also known as surrogate court system. They are similar to the civil and criminal court style, and it's important to note that there are key players that we need to discuss. And so there's a couple different people. So we have the juvenile defense attorney. And so, just like a regular defense attorney, they act for the individual who is being charged. So, in this case, the potential juvenile delinquent. And so, one thing where they differ, if you remember, we mentioned in Intro to Criminal Justice that the defense attorney is involved in most of the structure of the case from this point forward. In the juvenile system, they are 100%. They are, but the other thing is they're not just involved. They're actively involved. So you can be involved by simply, overhearing, and I don't mean overhearing like you're eavesdropping, but overhearing as in you're there and you're actively listening. You're hearing, you're putting your input forward, you're making decisions. The juvenile defense attorney is way more involved. They're involved in a lot of the aspects of the procedure. So they do, of course, act in the best interest of their clients, the juvenile delinquent, but they also they clarify jurisdictional problems. They decide whether there's sufficient evidence to go forward. They explore opportunities for informal adjustments. So, instead of going into the actual court system and going to trial, they would offer, alternatives to that. And then, of course, if it doesn't make it to court, they represent the juvenile in particular. And so there's another group of people. I'm writing this. It's referred to in our textbook as casa, or house in Spanish, which would be pronounced casa. I know that. But this is court appointed special advocates. So in the juvenile system, they have particularly people who are court appointed special advocates who their only job, they are meant to be advising the juvenile court about placement. And the other thing is, these are volunteers. So one thing that we will talk a little bit about when we talk about corrections, but we've talked a little bit about before already, is placement. So after a case, if a juvenile is found guilty, they need to be placed somewhere. And so there is a system in place that determines where they're going to go. But the CASA, the court appointed special advocates will give recommendations based off of reports, based off of the individual, based off of history, things of that nature, and be able to give a general idea of this individual would work really well in a very structured, strict location, whereas this one might do really well in a laid back kind of setting. That idea there is that they would make those recommendations. It's not that anyone has to take them, but they act as a neutral third party to explain some of those things. And just a little side note, I guess that I don't know why I didn't think of this before, but there are public defenders for juveniles. Like, I don't know why I didn't think about this, and why when I saw that, I was like, oh yeah, that does make perfect sense. I don't know why, but I think we tend to see the juvenile system as so separate that we forget about this. But yes, there are public defenders for juveniles, so if they can't afford an attorney, there is an option for it. If you remember in last week's notes, whichever video that was, I did mention that, we are the juvenile system is different. It's the same, but it's different. They are given the same rights. They have the same rules for the most part. So that means they would be allowed to have a public defender and that sort of thing. But obviously, we have defense attorney, but we also have prosecution. So we do have the juvenile prosecutor. Should be straightforward, but we know what this is. This is the person who... Oh, there we go. It's like my pen disappeared for half a second. So this is who represents the state, who brings the case forward against the juvenile. So there is the juvenile prosecutor. And so kind of just a little interesting history piece. As the juvenile system first came to be in the early 1900s, roughly the first 60 years, there was no prosecutor. So it was simply juvenile gets brought forward for these charges. Judge says yay or nay. They do have a defense, and then that's it. But so the first 60 years, there was no prosecutor. Now they do treat it like the traditional court system, and so there is a prosecutor that brings the state's argument, the state's case forward. And perhaps what is, I would argue, one of the most important figures in our juvenile court system is the juvenile judge. The court judge is the key central figure of the judicial court system. And part of that's because this goes back to Intro to Criminal Justice. The jury is known as the finders of fact, but in the juvenile system, the judge is the finder of fact, which means there's not a jury. It's the judge that makes that final decision. So they are important in that aspect, that they are the person who, you know, makes those calls, but they help determine what the rules are. They determine what kind of coverage and securities are in place for individuals. They don't just impact the case, but procedures, programs, rehabilitation. The juvenile judge is involved in a lot of the different aspects of the juvenile justice system. And so they are definitely a central figure. And so this is something that would appear on a quiz or test. Um, so like I said, they talk about policy, uh, programs, procedures, rehabilitation. The takeaway should be here that while the juvenile prosecutor is involved realistically only in the trial part, and the court appointed special advocate is really involved in the possible sentencing step, the juvenile defense attorney and the juvenile judge, those are the two key players. The defense attorney is actively involved and determines whether there is a case, and the judge is not only judge and jury, but they also play a role in making sure that things go the way they're supposed to. And so those are the key players. And so I've teased this already. I'm not going to go too deep into the process of the court itself, simply because we do that in intro. We discuss how the actual justice system operates, the court system from first reading all the way through sentencing. It's the same thing for the juvenile system, except with some different words, and we will talk about that. But we're going to look at it from a higher point, and so we're going to break it down into 4 key areas. We're going to talk about the pretrial, and so in pretrial itself, this is where a key decision is made. And it's weird to think about it, and this is definitely where the juvenile system differs. It still is similar in the adult court system, but it does differ. So, in the pretrial process of the juvenile system, several key decisions are made, but one of the big ones is release or detain. And so, what we're talking about is before the actual events of the trial happen, or before a decision to let go or whatever is made, they have to decide, do they release the youth back to legal guardians and home, and they're allowed to return to some semblance of normal life until their official trial, or are they detained, much like we detain criminals sometimes? We set things like bail in the adult system. I do want to note, it's important to say that there is bail for children, but it gets into a bigger issue, and we will talk about that here in just a second. But so the reality is, because the juvenile system is seen through a mostly social work lens, the goal seems to be release. And so that seems to be the one that people want to do because there are some studies and data to show that detention can be traumatizing. But there are several reasons to potentially detain an individual, a youth, during the pre-trial process. Some of those include, being homeless, potential runaway individual. They might be independent individual. So if those are the cases, they want to make sure that they are going to appear. So they tend to have that kind of thing. The idea here, they also will have, as far as detaining is concerned, these things that our textbook calls shelter care. It's almost like a temporary foster care kind of system where there is some kind of place where the court is okay to send them, but it's not to their actual home, that kind of thing. It's a kind of gray area, but yeah. Like I said, we see this in the adult trial, but it's way more prevalent and key in the juvenile system. And so this is where I bring up the issue of bail for children. So there is bail. That's the first thing I want to say. It's there, but it is a controversial point and a controversial opinion, much like we have issues with bail essentially being ways to incarcerate poorer individuals. The same with juveniles. So it is important to note that most states refuse juveniles the right to bail, but they do technically have it. And so the main argument is that juvenile proceedings are civil, not criminal, and so detention is rehabilitative, not punitive. So it's not punishment, it's supposed to be healing. So it's all good. So they argue juveniles don't need a constitutional right to bail because the provisions allow children to be released into parental custody. But again, it really depends on the state. So it falls into three categories: those guaranteeing the right to bail, those that grant the court discretion, and those that deny the right to bail. It's once again the fact that our court system, the United States American court system, is not a singular system. There is the federal courts and there are the state courts, and there are state laws versus federal laws. And since there's not a federal decision, it is up to the states. So that is just important to note. But that is part of the reason why there is this issue, is that not every state agrees on whether or not you should allow children bail. Anyway, that's just the pre-trial. Now we actually get to talk. And by the way, information about the bail issue is found on page 360 of our textbook, if you so choose to look into that. So our next step is the intake part of this, and truly the intake is screening. I clicked a button, that was on me. So specifically, the whole idea here at this point, I mean, it's part of this area, I guess. The intake process screens through all the cases and determine which ones go to court, which ones can be dismissed, what gets sent home, which individuals go to community services. The idea here is that the intake process, by doing this, we're looking at reduce caseload. And so if you remember back in Intro to Criminal Justice, we talked about how the court system is bogged down by a whole lot of backlog of cases. So the intake process, allowing screening in the juvenile system, frees up and reduces a lot of the caseload. So they can make determinations at this early of a stage to essentially release. I know I have release and release. Go to court, or sentencing. Really, what they're doing, they're making that decision at this stage. And so, in the intake process, there is a particular piece that is brought up, and that is diversion. Obviously, related to all this, diversion is all done all at intake, and it's referring individuals to treatment or care programs or release. That's what this little star is. This is what all this is about. This is diversion. It's determining where you want to go. That's all. So during the intake process, you're screening cases, attempting to reduce caseload, and you can make determinations like diversion or the other thing that we do get into this, and we're going to talk about this here in a second, petition. But we'll get to that in just a second. So there is a difference between screening and diversion. All right. So screening looks at all surface. So it just looks at the case, looks at the general kind of pieces about it, and makes a determination based off of that. Whereas diversion, or diverting part of this suggests, or rather encourages, a program. And so it's not a great explanation for it. But if you were trying to find a similar example to help drive the point home, screening is the idea of like probation. So you never are in the court system. You just kind of get pulled out of it. Whereas parole, you're in the court system. You've already been sentenced, and this is your good behavior chance to get out. To a point, that's kind of what I'm getting at, is that screening is this very surface level. You don't really go through the court system at all. But diversion, you're still not going through the full court system, but you are a little more in depth, and it's a little closer to this. You are still in the system kind of way of thinking. I hope I didn't confuse too many people with that, because that's what I'm trying to avoid. But so petitioning is something different, and this is if you remember in Intro to Criminal Justice, there is a phase in the early parts of the trial process in which the charges are formally read and a plea is entered into the courts. This is that petition stage. This is where the agency makes a report or complaint to the court to initiate the intake process, and this is where plea bargaining, starts to come in. And so, of course, this comes up at the weirdest, worst times. No. So the other thing with this is plea bargaining does come in, and again, much like everything else, we have plea bargains. Yes, Hollywood is not like plea bargaining, but it is a reality and a constant of our own system. Plea bargains also appear in the juvenile system. You agree that you did this, you get a lesser sentence. And so this is also the time where, uh-oh, my pen disappeared for half a second. Or is freaking out. That was weird. Anyway, uh, it is at this point in time that, yeah, waivers come into play here. And so if you remember, the waiver means that it is saying that the court itself, excuse me, the case itself will be transferred to adult criminal or civil court, usually criminal court, simply because the case is of a serious nature that the individual needs to be charged as an adult. So it is criminal court. Anyway, there are 3 ways. All states allow juveniles to be treated as adults in the criminal courts in one of 3 ways. And so when we talk about the 3 ways, this you can find on page 365 of our textbook. And so the ways in which a waiver can be put forward is concurrent jurisdiction. So in 14 states and Washington, D.C., prosecutor has the discretion of filing charges for certain offenses in either juvenile or criminal court. So in those 14 states and Washington, D.C., the prosecutor in the case has the ability to look at it and go, okay, this is actually a criminal case and they can be tried as an adult, or this isn't really that severe, it can go to juvenile court. There's also statutory exclusion policies. So in 29 states, certain offenses are automatically excluded from juvenile court. These occurrences can be minor, such as traffic violations, or more serious, like murder or rape. So statutory exclusion accounts for the largest numbers of juveniles tried as adults. These are why these are the ones that you tend to hear about and they're on the news. They're the murders and the rapes. These are the big ones that people hear about in the news. So statutory exclusion policies are in technically a majority of the states, 29 of the 50. And then the third one, and this one we have talked a little bit about, we haven't used the word, but judicial waiver. So in this waiver or bind over or removal, again, all those words, we've used this before. Of juvenile cases to criminal courts, a hearing is held before a juvenile court judge who then decides whether jurisdiction needs to be waived to go to a criminal court or otherwise. 44 states and Washington, D.C. offer provisions for juvenile waivers. So the 6 states that do not are Connecticut, Massachusetts, Montana, Nebraska, New Mexico, and New York. But in the rest of the United States, essentially a judicial judge can hear over the general facts of the case and can make a determination about whether it stays in juvenile court or goes to the next level. But either way, those are the 3 ways in which a waiver procedure can occur for a juvenile case to be brought to adult court. All right. And then we get to my favorite part, which, again, not subtle, and I've admitted this. I love the court process, so we get into the actual trial part. And so this is where I say it's structured the same way with opening statements, things of that nature. But if brought to court, and we have already mentioned this, there is no jury. This is one of those cases where the judge acts as the fact finder. The standard rules, like standard of proof, still apply. So it's not like you have to have less evidence or more evidence. It's still realistic. But during this phase, so a decision can be made. Well, how about I say this? As the finder of fact, the judge can find rulings. I'm just going to write this because I'm struggling to say it and write it. So our first option is in the finding of fact that the juvenile is not delinquent or in need of supervision. There's also the finding of fact that the juvenile is delinquent and in need of supervision. Or the third possible ruling or option in this is dismissing due to insufficient or faulty evidence. So, the judge gets to make this decision because there is no jury, so they are the person that hears the whole case. They oversee to make sure everything is followed by the rules, but they also get to make a decision. And so their decision breaks down into one of three primary rulings. One is that the juvenile is not delinquent or in need of supervision, and so it goes in favor of them. They find that the juvenile is in fact delinquent and in need of supervision, and so then we go into that next part, which is the sentencing. The case can be dismissed due to insufficient or faulty evidence, and so that's kind of an important piece. And so then we get into the sentencing part. And you should be going, Mr. Wheaton, you're not writing sentencing. You wrote disposition. And you're right. Why did I write training? I don't know why my brain did that. Apologies. But we're really talking about the sentencing. Disposition in the juvenile justice system is the sentencing step. And so one thing, going back to something we said way back at the beginning of this class, and so as a whole, the juvenile justice system tries to act in the best interest of the child. And so even here in the sentencing part, they try to make decisions based off the best interests of the child. Now, to dive into this at the disposition part, the judge can actually make a request. They can ask the probation department to compile information on the juvenile and come up with a a predisposition report, detailing information and also kind of putting forward suggestions for how to sentence the individual. This should sound familiar to anyone who is in Intro to Criminal Justice. If you remember back to the trial discussion, judges can also request the probation department to make a pre-sentencing report. Remember how I said it's pretty much the same thing with different words? Yeah. So this is one of those examples. The predisposition report that is done by the probation department. This is looking at house life. When I say house life, I really mean home life, because not every home is a house and things of that nature. But truly, this is just kind of getting into the nitty gritty of, all right, well, what does it actually look like? Are there specific things that are needed? So, there are a number of purposes for a predisposition report. One of them is, it helps the judge decide which sentence is the best. It also aids the juvenile probation officer in developing a treatment program when the child is in need of counseling or community supervision, because they're seeing this firsthand. They're seeing what actually is needed. And it also helps the court develop a body of knowledge about the child, so that it can aid other children. You can set precedent and kind of help move that forward in the correct way, that kind of idea. So yeah, the predisposition report is an important document. It does help kind of move these things forward, but yeah. Just as a real quick kind of overview point, whatever you want to say about it. So on page 375 of our textbook, we have exhibit, what is it, 13? Yes. I don't like this. Why aren't you working now? 13.4. And all that is common juvenile dispositions. So it's several different options. So it's things like probation, and it tells you what the action is. So disposition, probation, action taken. A youth is placed under the control of the county probation department and required to obey a set of probation rules and participate in a treatment program. Fines. Some states allow fines to be levied against juveniles age 16 and older. Drug and alcohol treatment. Youths with drug or alcohol-related problems may be allowed to remain in the community if they agree to undergo drug or alcohol therapy. I would urge you, hint, hint, nudge, nudge, wink, wink, any other hints I can give. Look at page 375, look at exhibit 13.4, and make yourself familiar with some of those terms and sentences, because they may show up on the final. Hint, hint, nudge, nudge. All right. And so, like I said, that is, those are common juvenile dispositions. So, important to look at. Hope you get the hint. Okay. So, the other thing that we need to talk about as far as this is concerned, we need to talk about the sentencing structure. Again, I know my writing's not the best, so hopefully you're listening and you hear me clearly enough that you can understand what I'm saying. But so most states, they follow this kind of rule that the juvenile system has, and that's the least detrimental alternative when deciding a program or placement for a juvenile. Because if you remember when we first started talking about this, the juvenile justice is rehabilitative in nature. It's looking for growth, specifically healthy growth. And so in thinking about sentencing, they want it to be the least restricting, the least detrimental, specifically to development. So, again, reminder that the juvenile justice system, you're dealing with youth. You're dealing with people who are still growing, who are still developing, who are still learning. That's why it's so important that a lot of places determine they try to do the least detrimental developmentally when sentencing an individual, because if you sentence a juvenile to the most severe punishment or location possible while they're still developing, that can have a long-term negative effect on the individual. And there's some data that supports that. So it's why we try to go for this. Remember, acting in the best interest of the child. Where, meanwhile in the adult system, we kind of just go, yeah, maybe. So, like adult sentencing, and so this is something else that I need to talk about briefly. We have different lengths for sentences. So we have our standard, the indeterminate sentence, the determinate sentence, and the mandatory sentence. If you don't remember, very briefly, determinate is a set time. Indeterminate, there's no set time. This could be forever. Mandatory is minimum required. So a mandatory sentence means you have to, by that bare minimum, hit that point. So again, much like the adult system, there are different lengths of sentencing. So a juvenile can be placed technically in a rehabilitative location for an indeterminate amount of time. So that means they could be there for 1 month or maybe until they age out of the system. And so there is kind of a big difference in between the adult system and the juvenile system. So there's no death penalty in the juvenile system. At least not since 2005. So, yeah. They're not allowed to be sentenced to death, and there is no life sentencing without chance of parole. This comes down to the concept that I just kind of mentioned before, that you are dealing with juveniles. You're dealing with people who are still developing and they're not quite finalized in who they are, how they're going to be. So the idea is, if you offer no parole chances for a life sentence, if that person changed, is it fair for you to do that? No, so you have to offer them potential of parole as they get older. So it does raise some issues, especially when we consider cases of murder. Some people would be like, they shouldn't be allowed to have parole, but were they a young, dumb kid that made a stupid decision? Did they intend to kill? You can bring up so many possible issues, but it's important to note that in the juvenile system, there is no death penalty and there is no chance for a life sentence without the chance for parole. Obviously, the other thing with this, sorry, I was reading something separately. So, much like I've mentioned before, a lot of juveniles, or rather, juveniles have the same or similar rights as adults who are sentenced, so they can appeal their sentencing. It's a little more complicated than that, but one thing that I did want to emphasize is confidentiality. There was an issue and is an issue about whether a juvenile case can be public or not. Obviously, we've talked about a couple examples in this class and those discussion boards. I brought up the Slenderman killings and the Columbine shootings. Some of you brought up some other important, technically juvenile cases, and so there's a lot to this. And so obviously they are open, but for the most part, there is this kind of security of keeping juvenile cases quiet or from the general public eye. They're typically not they're not televised for sure, but there are extra layers to protect what is essentially a child, and we have to remember that even when they commit heinous crimes and acts, that they are still children, and so they are offered some protections from the general public and things of that nature. All right, well, that ends chapter 13, talking about the court system of the juvenile justice system. Big takeaway is it's very similar, but there are some key differences, specifically in terminology, that the judge is the primary individual that makes a lot of decisions, and essentially kids can't be put to death or given life without potential for parole. Doesn't mean they'll get it, but they can or cannot get it. Anyway, thank you very much. The next video will be our last lecture video. So I'll see you when we talk about juvenile probation. Bye for now.